we're going to take up Representative Edmonds. Representative Edmonds, 1019. And while Representative Edmonds is coming to the desk, I'll give him some time to prepare. Some house cleaning on HCR 87. In support was Deanna Wallace, Ben Clapper, Ryan Verrett, and Tony Buxton for informational purposes, and did not wish to speak, but not in support, Corrine Green. On HCR 97, cards of support, Pete Martinez, Jennifer Marusak, Wes Hadaway, Sabrina Noah, and Jeff Williams. And Representative Edmonds, we want to thank you. I know last week you kind of got bogged down for time, so we want to welcome you to the committee. And just for the opponents and the proponents of the bill, if we do see some duplication of testimony, we may use some discretion from the chair, and we just would ask that we stay on the bill itself, and because we do have some time constraints.
Thank you, Mr. Chairman. Thank you, members. Good afternoon. HB 1019 prohibits the performance of an abortion, any attempt to perform an abortion when a pregnant woman seeks the abortion solely because of a genetic abnormality of the unborn child. Every year in the United States, approximately 133,000 pregnant mothers will undergo routine prenatal tests and receive what is called a poor prenatal diagnosis. This means that their infant is afflicted with a chromosomal abnormality or a serious defect in a vital organ. Tragically, more than 90% of these pregnancies end in abortion. And today, to be brief as we can, as the chairman has reminded us, we are have the opportunity. We didn't have the treat last week. You guys didn't get to meet Jacob and Catherine Hall. They had the opportunity to be on the House side with us weeks ago, and so we're honored to have them here for a few moments as well. Mr. Chairman, if it be appropriate, I'd like them to speak for the bill.
Welcome, Jacob. We're happy to have you here. Welcome.
Thank you.
Ms. Hall, would you like to go first?
Yes, thank you.
Thank you, and welcome.
Good afternoon, members. My name is Catherine Hall, and my husband, Will Hall, is the Director of the Office of Public Policy for the Louisiana Baptist Convention, and he has asked me to represent the consensus held by Louisiana Baptist. But I am really here as a mother to represent my son, Jacob. Jacob has just completed his senior year at Tioga High School in Ball, Louisiana, where he continues to progress academically and where he serves his local community through volunteering at the local food bank and at Helping Hands Clothes Closet and at the local Max Super Fresh Market along with his classmates. He also enjoys singing, drumming, preaching, and participated in Special Olympics and the Rapides Games. He is a major motorcycle aficionado, and he is an honorary member of the Faith Riders of Philadelphia Baptist Church and has completed a couple of benefit runs. And in addition, with you, Senator Mills, he loves wrestling.
I used to be a wrestling announcer.
That's right.
I'll get you some tapes.
Jacob has an infectious personality. He rarely meets a stranger, and he loves life. He is a young man confident in his own skin. But this life might not have happened had I listened to my doctor, who repeatedly persisted and presented the worst case scenarios during my pregnancy. My husband, Will, and I were delighted when we learned of our pregnancy in early 1997. And due to my age, I was referred to genetic counseling. And as part of that procedure was given the alpha-theta protein blood test, which resulted in a 1 in 12 probability that Jacob would be born with genetic abnormalities, specifically Down syndrome. The doctor persisted to paint the worst case scenario of a bleak and burdensome life for our son, a diminished quality of life, a multitude of physical and mental health issues, negative impact on our finances, on parenting, on his siblings, and even our marriage. The doctor strongly urged us to have an amniocentesis. This is a procedure in which a needle is inserted into the uterus to extract the amnio fluid surrounding the baby. I asked several questions at that point. I asked, can you treat my child's concerns in utero? The answer was no. I asked if they would treat my pregnancy differently, and the answer was no. And I asked if they would do anything differently at birth if I did this procedure, and the answer was no. And then I asked if there was a risk to my baby during this procedure, and the answer was yes. The doctor persisted, but you've got to make an informed decision. And it was at that time that I looked at my husband and back to the doctor and told him that that decision had been made, that we were informed, and that I indeed was pregnant. And so my pregnancy continued. We did not know definitively if there would be complications or issues to face. But ladies and gentlemen, there are none of us that are free from a complication-filled life. And indeed, when Jacob was born, there were many issues at hand. The umbilical cord was wrapped around his neck, and he had aspirated meconium into his lungs. The heart was continuing to function as though it was still in the womb. The kidneys were shutting down, and there were liver processing issues, and he had immature platelets, which required multiple blood transfusions. Oh, and yes, he did have Down syndrome. But above all, we simply wanted this precious life to survive. The first week, Jacob was on a ventilator and could have minimal stimulation as he fought to survive. I sat by his side, I hummed and prayed that he would know my voice and sense my closeness since I could not touch him. The doctors had told us to prepare for his death. But on Wednesday, after his Sunday birth, the doctors came in and told us that Jacob had turned the corner. At the end of that week, we got to hold him for the very first time. And 5 weeks later, we went home. Over the years, there have been multiple surgeries. We've had heart, eyes, ears, tonsils, adenoid surgery, and long hours of physical, occupational, and speech therapy. Jacob is deaf in his left ear. He has post-cataract vision of 2400, which renders him legally blind without aid. He has cognitive limitations, and his speech intelligibility does bring some challenges. However, I am happy to say that Jacob's health is stable. He enjoys life, and he loves people, and people respond to him. Jacob enjoys helping most days, and he seems to have a special intuition as to when someone needs a hug or a prayer. And Will and I can stand before you today and tell you that Jacob's life has enriched our own and grown us. He tends to challenge people, bringing out their better qualities. Throughout the years, we've had multiple opportunities to interface with many families with special needs children in whose lives they delight. Jacob has taught us unconditional love, acceptance of others. He's grown us in compassion, perspective, and perseverance, and he enriches the lives of others. In particular, I enjoy observing members of the Tioga Buddy Club as they interact with Jacob and others in his class. I witness these students of the general population maturing in their respect for others, in responsibility, in developing leadership skills, and in sharing compassion. I've had a number of those students and ones in our previous school who have shared with us how much that this buddy experience has impacted their life and encouraged their own personal goals. And Jacob himself has made an even greater contribution, and that he actually helped to save 2 lives. After his birth, we were asked by the hospital to counsel with other families who were facing similar situations and had received diagnoses of Down syndrome. In particular, there were 2 families that we counseled with, and after seeing and holding Jacob, I'm happy to report that both families chose life. It is my plea that you would do the same in passing House Bill 1019. I ask that you look at Jacob, the individual, and not the abnormality. I beseech you to vote for what we tenderly call Jacob's Law. No parent should have the right to kill a child based upon a birth abnormality diagnosis. I would ask that you prevent selective abortion and give all future Jacobs in Louisiana the opportunity to embrace their own life and to enrich the lives of others that they touch. I thank you each for your time and consideration.
Thank you, Ms. Hall. Thank you for your presentation.
Absolutely.
Jacob, did you want to tell us anything?
Yeah.
What do you want to tell him?
If you'd like to talk, it's your turn.
Oh, yeah?
Yeah.
You want to tell him what you like to do?
Yeah.
Tell him. School.
They put me in.
Do you like school?
Yeah.
School and wrestling?
Exactly.
You like to play ball?
Play a ball.
And sing.
I sing, watch me, and music.
And music.
Well, we're happy to have you here. Let's give everybody Jacob a big round of applause. Thank you. Thank you for being here. I have no questions by the committee at this moment. I do have a couple of more cards in support that would like to speak. Mr. Gene Mills, Reverend Gene Mills with Louisiana Family Forum, and Deanna Wallace from Louisiana Right to Life. If you'd like to speak, now is the opportunity. And thank you again, Ms. Hall, for being here. And Jacob, thank you for being also here.
You're welcome.
Thank you, Jacob.
You're welcome, my man.
Right, you have to represent. You have a question? Okay. Would you like the presentation? Okay. We do have some questions, so we'll give you all a chance to present, then we'll start the questioning on the bill.
Thank
Dr.
you,
Mills,
Mr.
I'd
Chairman.
like to recognize that his father, Will Hall, is in the middle of the audience, so Dr. Hall is here with his son, Jacob.
Dr. Hall, welcome always. We've met before. Welcome.
Thank
Glad
you,
to
Mr.
have you
Chair.
here.
Mr. Chairman, members of the committee, thank you for the opportunity to briefly speak on this bill. HB 1019 prohibits abortion solely because of a genetic abnormality of an unborn child. As the author of the bill has just mentioned, every year approximately 133,000 women undergo routine prenatal tests and receive what is called a poor prenatal diagnosis. Now, we need to know that poor prenatal diagnosis doesn't always ultimately mean that there will actually be an abnormality. And that's one of the things that I wanted to highlight to you today. However, it does mean that oftentimes there are abnormalities that must be considered. And it's how we do that sensitively that I'd like to call to your attention. This means the preborn child is perceived to be afflicted with a serious concern. Tragically, most of those, about 90%, of those pregnancies will end in an abortion. And there's a reason why. Because when abortion is the preferred course of treatment, not only is the baby's life ended, but oftentimes the parents' lives are changed forever. Assuming power over life and death has dire consequences beyond the immediate decision. Expected parents who feel pressure from doctors, therapists, and others in the medical profession or friends and family to terminate a pregnancy because they're facing grim prospects are often the vulnerable ones who ought not be put under pressure by authorities when they're processing their course of action or decision. Sadly, the best of intentions by healthcare professionals, friend and family can often feed our worst fears. Life-affirming alternatives with respect to the dignity of the unborn life is always in the best interest of the mother and the child, and the father as well, and the relationship. Most couples only receive non-directive counseling, which means they're told only the challenges, the conditions, and often without offering life-affirming encouragement. This bad news can be overwhelming and lead parents to believe that abortion is the only solution. However, information gleaned from prenatal testing should always be subject to the same life ethic that this body and this committee and this state is known for, and that's what we're calling for. I will tell you this on a personal note, and that ends my testimony. My best friend in high school and my wife's best friend in high school, separate high schools, met at college at LSU. He was an athlete that played ball for LSU. She was a cheerleader from Notre Dame out of Eunice in Crawley, Louisiana, and they met at a Bible study and later became courted because of our friendship, married, and their first child was one of these children. And they were told because of the result of the prenatal test that the young child's brain was outside of the spinal cord and outside of the cranial skull, and that it had no chance of living. But I got to tell you, Women's Hospital treated that situation with such medical care and the ethics that are afforded to every life that they allowed, and this was some 25, 30 years ago, they allowed this child and this family to make a very life-affirming decision to deliver that child, and Annie and Ronnie rocked that child into the presence of God. and with dignity received that life into their lives and loved that child, and then gave it a proper Christian burial. We believe that that is not a too difficult thing to ask. This does not take away a woman's right to a decision. It just affirms the right and the dignity of every single life, even those who happen to have the malaise that we're talking about today. Thank you, members. I would encourage your positive affirmation of this bill.
Thank you, Reverend. And we do have questions, so we'll let the panel give you a presentation, and we'll open up for questions from the committee. Yes, ma'am.
Thank you, Mr. Chairman. My name is Deanna Wallace with Louisiana Right to Life. I'm the legislative director and also an attorney. We've heard, the stories here today that Gene Mills has told and the Halls have told, and this is not an uncommon story. We heard our own governor and first lady during the campaign season share their story of how their doctor also encouraged them, based on a prenatal diagnosis, to abort their child, and that they chose life. My first day on the job, I had the privilege to go to New Orleans to the St. Michael's Special School for a meeting with the Jerome Lejeune Foundation, which is an international nonprofit research organization that studies how to treat and provide therapeutic treatments for those with Down syndrome and other intellectual disabilities. And I got to hear from a room full of parents the same exact story, that their doctors encouraged them to abort without giving them any sort of information about the spectrum of the disease and how, that their child could live a very satisfactory life and could, thrive. Instead, they were discouraged and told, don't worry, we can schedule a termination tomorrow. And this is something that happens every day in our state. And so we believe that if women were not being coerced by their doctors and this medical information that's lacking the full information about all of the beautiful children that have risen above their initial diagnosis, that they would be able to choose a life-affirming choice. And I do have a letter from the Jerome Lejeune Foundation's American chapter in support of this legislation that I would love to present to the committee. And very briefly, I know that it's come up several times before, the legal aspects of bills like this. In 1990, Congress passed the Americans with Disability Act, and in that act, Congress found that the physical or mental disabilities in no way diminish a person's right to fully participate in all aspects of society. Yet many people with physical or mental disabilities have been precluded from doing so because of discrimination. Ladies and gentlemen of the committee, there can be no worse discrimination than deadly discrimination through abortion. Denying someone the fundamental right to life based on a diagnosis of disability is extremely discriminatory. And we believe that this bill is a natural extension of the Americans with Disability Act. In addition, it preserves the ethics and integrity of the medical profession by discouraging the unethical pressure and coercion that does unfortunately accompany a poor prenatal diagnosis. And in Carhart, the Supreme Court upheld the fact that we do have, as a state, the right to preserve the ethics and integrity of the medical profession, even when it does come to the abortion decision. And in furtherance of the legal issues that might come up, I do have a summary of a friend of the court brief that the Bioethics Defense Fund, many of you know Ms. Dorinda Bordley, she was working on a brief with Arizona dealing with their 20-week ban, which we also have here, based on disability discrimination. So I'd like to also present you with a brief summary of that study that she presented to the court in Arizona to help try to explain the legal analysis of why disability discrimination is not something that the court has ever upheld in the abortion or any other industry. And so that is all, and I...
Thank you. Why don't we open it up for questions? And I do think you have an amendment on the desk that you'd like us to consider. Why don't we open up for questions with the committee, and then we'll entertain your amendment. Okay. Senator Luno, you've been patiently waiting. Thank you.
Thank you, Mr. Chair. Ma'am, you are right. We've had these discussions on every one of these bills, and one of the things that we're not doing our job as senators is asking you the questions about what the current posture of this. Have any of these cases been tried in other states? Have they gone up the system? Where are we at in the litigation chain dealing with this issue?
So these types of bills, we call them PRENDA bills, Prenatal Non-Discrimination Acts, have not gone very far. First of all, some of them are much more broad. They include sex selection and race selection as well.
Let me stop you. Let's get back to my question.
Right.
Where are we at on the cases? Have they been won or lost on this issue?
The point I was trying to make is that they have not progressed to a point where I can give you any sort of information on whether or not it's been upheld. Most of them are still pending.
There haven't been any decisions by any lower courts or anything on it?
They have had injunctions, but no merits cases that I'm aware of that I could find in my research. Simply
Injunctions were
injunctions.
granted by whatever state they were in?
Yes, by lower
Okay.
courts.
But no decisions on it one way
No
or the other?
decisions on the merits. The brief that I gave y'all deals not with a specific ban on disability, but an argument against the 20-week ban in Arizona, which we also have the 20-week ban. It's never been challenged here. But the argument was that because most prenatal diagnoses that might require or that might make a woman desire to end her pregnancy are not found until after 20 weeks. So that's the closest that we can get to a case that's actually been heard on the merits.
Okay. All right, thank you.
Thank you, Senator. Senator Brown, you up next.
Ma'am, how are you? I want to see if you all can help us to understand. If we pass this, we're basically saying no matter whatever range, minor to moderate of a medically futile, as is defined, situation a person's fetus has, this bill, if this bill passed in its current posture, it would take away totally their ability to decide if they choose to have an abortion only because of the medically futile state that the fetus is in.
I believe that the actual bill would only apply if it was not medically futile and that had not been a diagnosis by a competent. Okay.
That's what I said.
So if we're
it
talking
is,
about,
it takes away their right to choose.
if it is not medically futile, then it does. The Louisiana would be upholding the dignity of that child and saying that you cannot discriminate against them.
Now, make us understand. I just need to know, because I would think, as I'm hearing this dialogue, I think about my son. My son is a perfectly normal child, but I think that when my wife was pregnant, if there were some issues up to a certain range, she may have wanted to consider an abortion. And I preface that to ask the question, why would we want to take away some people's ability to have some people's freedom to make that choice on their own individually, as opposed to us mandating that they cannot do it?
I think that would be based on the same reasons that Congress said that you can't, as a business, choose not to provide accommodations for people with disabilities, because that is discrimination. At some point, we have to say
But Congress
that
says a
you
lot
deserve
of things.
protection.
Congress says a lot of things that we still don't do.
I agree, but I believe that
I have another bill, or should I say a resolution, that talks about why less than 10% of African Americans in the River Parish and Bayou Region area are not working at the chemical plants, when there's about 40% out-of-state people living in my area, and the biggest industry going on in my area right now is travel trailer parks, because they don't want to hire local. So a lot of things Congress say we don't do. So make me understand why Congress also passed laws to give the developmentally disabled the freedom to choose the things they want to be able to live a normal life. Mm-hmm. Why would we not want to give specifically a mother or a potential mother or a woman or a couple the right to choose?
Senator Brown,
in certain cases.
if you don't mind.
You're good.
When a mother or couple is given some of a said diagnosis, it obviously is a very emotional time for most. And what we're trying to do is what we've done in this state over a variety of cases is to still protect life. To say that they're even in an abnormality, that a child has lost its purpose, we believe is a very dangerous thing to say to the parent. And thus, what has happened in the cases that we've studied and seen through the years, and the testimony that you've heard here this afternoon, is that even though life is hard and times sometimes are extremely difficult, that when we attempt to take away some of those difficulties, it does not necessarily produce the fruit that we're looking for.
But sometimes it does. And I'll give you another rationale. A woman that's pregnant and she miscarries, she goes through that same emotional state that you just explained, but she still has the right to choose whether she wants to conceive again and have a child. And that child could very well be totally normal.
Could be.
But that same woman should as well have a right to say whether they want to have an abortion or not, if they're presented with some details from their physician that make them give that due consideration. What you're saying is you're drawing a conclusion to say that a person that is going through that type of emotional state cannot make a reasonable and just decision for herself. Am I correct?
Based on this particular statute, we're saying that life is precious at all points, and that you will not be able to abort a child that has this abnormality, and you select for that purpose alone. You are correct.
But again, that is to draw the conclusion that a person in that state cannot make a reasonable and just decision for themselves. So government is going to do it.
We are protecting life, as we have in a variety of ways. This is one of many bills that we are protecting life on.
Have you seen the murder rate in Louisiana?
I have.
Seen the murder rate in this nation? You think we protecting life? With the statutes that's on the books, first-degree murder, second-degree murder, manslaughter, do you compare to some of our global competitors? Because there's a lot of places in the nation, in the world, that don't have murder rates nowhere near the United States, right? But when you look at their punishment, it's totally different from our punishments as well. So again, are we truly protecting life?
Well, I don't know that I go the line of questioning, Senator Brown, and I appreciate, I shouldn't think what you're trying to think, but it would almost seem to me that would mean that we would remove cases of murder or first, second-degree murder. If we thought that was not protecting life, then we would eliminate those bills from our structure, and thus we'd become a safer society, which I would not agree with.
I don't think the ultimate goal of those bills is to protect life. The ultimate goals of those bills is to punish those who commit those crimes. I'm concerned more about the freedom for a reasonable person to be able to make their own decision, as opposed to us making their decision, especially when it comes to conception and having a child and having to deal with the responsibilities that will come with that child once it's born. And no one knows an individual's position but themselves when it comes to making that decision. I mean, we all understand ourselves individually from a financial standpoint, from a realistic standpoint, and a social standpoint. But you may have someone out there that just feel that they can take care of a normal child, but when they look at dynamics that are put before them, they may have to reconsider and make necessary adjustments, if they can make the necessary adjustments to take care of that type fetus, whatever that may be. I'm speaking from a general sense, and decide whether abortion or not abortion is feasible for them. What you're saying is basically we're not giving them that freedom to choose, but we give most others the freedom to choose in this country. Thank you.
Thank you, Senator Brown. Senator Barrow, you up next.
Thank you. And we certainly have had a lot of debate and discussion on this. And Representative Edmonds, as I was listening, the first thing that came to my mind is that we are a product of our training, our education, and our experience. And I thought about my nephew, who is now 25. And when my sister, who was in the Army and came back, and that was her second pregnancy, we were informed that he had some abnormalities and that he would not have a good quality of life. We were told. And they wanted my sister to have an abortion. They thought that would be the best option for her to make. And so we received the information, and being people of faith, we just believed God that we would go ahead and go through and encourage my sister to have this baby. Now, she initially was not very happy because she was just thinking about all the things she had to deal with as being a mother. And so I never forget when he was delivered and when we saw him, he did not look abnormal. But there were some things that were wrong. And so she said, what are we going to call him? And so I looked up a name, and his name is Jarvis, which means keen and smart. So I said, every time we call his name, we're going to say that he's keen and he's smart. So we were told that he would never walk, he would never talk, he would never be able to function in society. He is now 25 and he has a job. He cuts grass. He's one of the people who participate in our society with the Disability Act because he was hired on with a company that see the importance of hiring individuals with disabilities. He makes his own money and he knows how to spend it. Every child in our family gravitates to him. When we get together, all my nieces and nephews run to Jarvis. If they are crying, who can comfort them? Jarvis. So, while sometimes we receive this information from physicians, it's not always accurate. And if we had followed the advice, recommendation, suggestion, whatever you want to call it, we would have missed out on a great blessing to our family and to this society. Mm-hmm. And so I really believe all life has value. And I tell you, I have many other stories that I could talk about that have been horrific. Mm-hmm. But I believe that all life has value. And so as I think about, some of the comments that have been made earlier, people have options. At the end of the day, I know families who have adopted children, and some, I believe, are called to adopt children who are abnormal. I know a lady personally that have 3 children that have special needs, and I commend her because it takes a great person to do that, and she adopted them. So there are always options. So I commend you for this bill. I thank you for it. And Mr. Chairman, I see the amendment, and I'd like to offer it up at the proper time.
Sure, I think we could offer it up now, and the amendment is offered up. It's 2816, and it adds, you want to talk about your amendment, Representative Edmonds? Would you like to explain your amendment to the committee?
We want to make certain that we, I think, tighten up the legislation in the terms of diagnosed, which we'll read into the record, means a determination made by a physician based on the results obtained from any genetic screening or prenatal testing procedure to detect a genetic abnormality. And that we felt like we didn't get that on the House side, Mr. Chairman. We thought we should bring that on this side.
So it was kind of your intent just to make sure you added this?
Yes, sir.
Okay.
Mm-hmm.
Any questions on the amendment? Seeing no questions on the amendment, we have a motion by Senator Barrow to adopt amendments 2816 to House Bill 1019. Seeing no opposition, that amendment has been adopted. We do have a question by Senator Clater.
Thank you, Mr. Chairman. I'm sort of like Gene, where when he was talking there, he got a lump in his throat and had difficulty talking about this for a minute, and that I am very pro-life, and I love all of God's children, and I appreciate having Jacob here today, where I've got a tender spot in my heart for the developmental disability community, and I don't even like the language that goes along with it, because I don't find anything abnormal about Jacob. He's just a sweet kid here making a presentation today. So it's difficult for me to talk about these issues sometime, and it's just because I care so much about them like everybody else. But at the same time, when I look at this, I go, how in the world are we going to enforce that? And I don't want anybody to get a mistaken impression. You look at my record as far as what I voted on. I've been 100% pro-life down the line. I've gotten the award from the groups that do that, and I've been a big advocate for inclusion for kids with disabilities. But I'll just make it into a couple of questions. And I'm not saying I agree with it. I'm just saying it's the law. As I understand the law now, you have abortion on demand, essentially, within a certain time period. And if somebody goes in and tells the doctor, I want an abortion within the time frame that's currently legal, and I want it because I think my child has a genetic abnormality, and I'm going to say God's going to judge that person at the appropriate time. But how is that not legal?
So what this bill would be doing is not making it illegal for her. It's making it illegal for the doctor to knowingly perform for that exact purpose. So if a woman goes into the clinic and just says, I want an abortion, then that's one issue. But if the doctor is told and knowingly performs the abortion for the express purpose of killing an innocent child that has a developmental disability, then that is what we are going after. It's that intention that matters.
And I hear what you're saying, and I don't have any problems with the moral side of the thing, but I see the Supreme Court rulings, and I think I understand the law. I know Representative Edmonds and Gene and all the people here have good hearts on what we're trying to advance, but it seems to me that it wouldn't be constitutional. It's patently unconstitutional on its face. But give me some comfort that it's not.
Right. Well, I did give you the brief summary
I heard you answer Senator Luna's questions.
Right. So we don't have any cases on point to give you right now because this has never been heard on the merits of the case. But we do have Supreme Court precedent ever since Planned Parenthood versus Casey in 1992, where every restriction on abortion to this point has been upheld by the court, including the swing vote of Justice Kennedy, who, while being pro-choice, has upheld these specific regulations. So we do believe that the court has been moving towards allowing more and more restrictions within the inner workings of Roe v. Wade and Planned Parenthood versus Casey. And we believe that based on things like the American Disability Act and the increasing of technology that allows these children to be treated both in the womb and out of the womb for a lot of different genetic abnormalities, that the need for abortion is something that the Supreme Court will not uphold in these cases. Again, the Supreme Court has consistently recognized that a state has a interest in protecting the ethics and integrity of the medical profession. And when we're talking about a eugenic practice like this, where we are specifically targeting individuals based on their genetic abnormality or disability, that we do have that ability to limit that practice because of the fact that it is unethical for many, many eugenic reasons.
Well, I appreciate what you're saying. I appreciate the bill. At the same time, for those of us that are pro-life day in and day out, when we bring a bill like this, to me, that on its face is not constitutional, puts me in a position where I have to vote against a bill like this, and people question or not whether or not you're pro-life. Where I'm not looking to out pro-life somebody else or wear badges on that. I mean, I'm pro-life. People ask me that question, and I answer it, and that's part of the deal on where they know where I stand. But when I get one like this, it puts me in a box of, do I go with the Constitution and what I know is clearly the way it is, or do I make a decision against my oath and say, well, maybe it's gray?
May I address that?
Please.
And
I'm looking for the way out of the box.
This is not from I had the same question when I saw this bill, but as I read the bill, it does not it does not abridge a woman's decision or ability to procure or obtain an abortion. The limits would be placed upon the prenatal doctor that's testing for genetic abnormalities. In A Woman's Right to Know, we say that informed consent cannot be provided without certain conditions applying, and that in order for a fully informed medical consent to be given to terminate or carry to term, certain provisions and understanding needs to be given in a compassionate environment. We feel like when you're dealing with a potential disability, that same ethic ought to be brought into that circumstance before that informed consent can be provided. And so that solely based on has the tendency to do with the conversation that a genetic test is having with a scared parent over what I must do and how I might provide that informed consent. So as I read the bill, it places the limitation upon the doctor and the medical professions in providing what would be the best possible environment to make a decision as the young woman continues to exercise her full liberty. But she does so in an environment that is neither compelled nor forced nor told only the blank or the starch medical facts, but rather the realization that they could be mistaken.
And I hear what you're saying, and we had the last bill in here on the 72-hour period and having appropriate counseling to think about it. I wish Jacob and his mom and dad were there every time somebody's results came back in a way to where they thought about it. And Javara's folks were there as well. I don't think that they would make such a decision with that kind of information, but if we're putting the hat on the doctor or we're putting the hat on the woman, I don't think it will pass constitutional muster. So I don't just speak for me. I don't like being placed in a box like this where it makes you appear as though you're non-right to life when I'm just having to follow the Constitution. I'm not chiding anybody. I'm just saying I find myself in a box on this, and it's I don't speak for anybody else other than myself on it. So I hear what you're saying. I've read the bill, and I'll pass to the next person. Mr. Chairman, thank you.
Thank you very much, Senator.
Before we switch over, I would just like to inform Senator Claytor that this type of legislation is being fought for by very prominent legal organizations within the pro-life movement, such as Americans United for Life, the Bioethics Defense Fund, and Alliance Defending Freedom, all organizations that deal specifically just with constitutional law and issues like this. And they do believe that it's a bill and a stand worth taking to the Supreme Court because they believe that we can make this happen.
I hear what you're saying, but they're not sitting in this chair having to make the vote. So thank you.
Thank you, Senator Claytor. Senator Luno?
I got the same problems. I mean, these folks may very well be my constituents. They may live in my district. The line's nearby where they live. And you guys are putting me in a box that I got to vote for something that I firmly, definitely believe is unconstitutional, or I got to vote against them. We have spent hundreds of thousands of dollars defending unconstitutional laws in this state. We should take that money and help children like this instead of throwing it away on something that we cannot win. If we can't win, why are we doing this? And I know all of the arguments about maybe this will be the one that changes it and all that. We can't afford it. We're broke. We've spent so much money doing this. It has to come down to some kind of common sense being included in it. Now, I mean, I understand your argument, but I wouldn't buy it in 100 years. It's not impeding the woman's right, it's the doctor. It's not. It's not. It's impeding the woman's right to have an abortion. I don't agree with it. I'm pro-life. I don't like abortion. I wish it wasn't legal. It is. We have to deal with it. We haven't been successful in changing that on a national level, so we have to deal with it whether we like it or not. And we owe the people of the state of Louisiana, we owe them enough to be honest about this. And if I'm being honest about it, I'm like Senator Claytor. I think this is clearly unconstitutional.
Mr. Chairman, if I may.
Sure.
Those organizations that were just mentioned take that very seriously, too. Our litigation arm, the Alliance Defending Freedom, has brought some 30 cases before the U.S. Supreme Court and prevailed in 28 of those. We share that same concern. I concur this one hasn't been tested, but I also believe that it's important to realize that doesn't necessarily mean that it won't be tested successfully.
Senator Luna, I think you wanted to.
Bring us a bill that we have a chance with.
To be fair,
I think we just get killed on this one, and I think we spend hundreds of thousands of dollars in the process that we don't have. I want to help these folks. I really do, but I just don't see how this one's going to work at all. And I appreciate the stuff you gave me, but you understand there's a whole other side to this argument than what you handed us today, and they've been winning, consistently winning on this issue. Again, this legislature is not the place to change that law. Go to Washington, D.C. and change it, and then we won't have these problems. We can deal with it. You understand? I mean, I just, I want to be for you, but you make it so difficult when you, like Senator Claytor said, you put us in a box. We either have to vote for something that we firmly believe is unconstitutional and won't pass, and it's going to cost us a lot of money, or we have to vote against people like this who are good people.
And Senator Luna, I think you're very mistaken on whether or not we've been consistently losing or winning. The Supreme Court has not struck down a single abortion restriction since 1992. And we have not lost a case here recently at all. The admitting privileges bill that I would think that you're referring to, we have one at the Fifth Circuit, and it is still pending at the Fifth Circuit.
What's the decision from every other circuit that's ruled on it?
On admitting privileges, it's a split in the circuit. That's why it's
Fifth Circuit has voted.
The Fifth
separately.
Circuit has voted to uphold it. There's a
Correct.
split in the circuits. That's why the Supreme Court is still considering.
Fifth Circuit, the most conservative circuit in the United States. Okay? It doesn't mean that's going to be a win. It's incredibly expensive to fight this on this front. I applaud what you're trying to do. I just ask you to please put it in a posture where we have a realistic chance at it. This is not, we can't win this battle in this legislature. Okay? And it just, anyway, you understand my point I'm making. Thank you.
Thank you, Senator Luna. Senator Barrow.
Mr. Chairman, we've adopted the amendment, correct?
Yes, we have adopted
at
the
the
amendment.
appropriate time, in terms of trying to keep with our time frame, I would like to report House Bill 1019 as amended favorably.
All right, we'll hold that amendment. I do have a question from Senator Brown. Senator Brown?
I kind of was going, feeling the same way these gentlemen was feeling that they got to the end result. I didn't get there, but please hear what we're saying, and this is where we are. You bring a bill like this, we see a challenge. We see a court challenge. We see money being spent. We had that going on since 2 years ago. And right now, I don't know if it's the right time to let that happen again. We see right now this is highly likely that will happen. So please understand our position. And our position is coming from a lot of different fronts. Constitutional challenge, as well as impeding on a woman's right to choose. That's where I am. Let me clear the record. There's a motion on the table.
There's a motion on the table and a question from Senator Clater after you follow. Oh, you done? Senator Clater?
Thank you. There's been a discussion about money. Maybe I'm wasteful. I don't mind spending money on this issue. I mind being a hypocrite. I take an oath to uphold the Constitution of the United States and of Louisiana, so that's the box that I'm in. I just want to make that absolutely clear. Thank you.
Thank you, and it looks like the board is clear. Just a thought, because I know we've all worked together on bills, and we'll get this now to a vote. Have you considered any type of mandatory notification period where a notification would take place and there'd be some documentation on this? Have y'all thought any of that? And I'll leave that to y'all down between here and the floor, but it seems like everybody's looking for if it makes it to the floor. Okay, let me read in support and in opposition before the vote. In support, Mr. Gene Mills, Jacob Hall, Catherine Hall, Deanna Wallace, Dr. Will Hall, Kathleen Benfield, Ryan Verrett, Ben Clapper, Rob Tasman. In opposition but not wishing to speak, Lauren Green and Eddie Lau. I'm sorry, there is someone here for informational purposes. Ashley McReynolds says I'm present, but I would like to speak. Is Ashley here? Okay. Ashley, before the vote, we do have an amendment pending. A motion pending. We do also have one card in opposition. Also, an additional card, D.W. Hunt, is here but would not like to speak. You would like to speak? Okay, please come on up. So welcome, Ms. McReynolds and Mr. Hunt. Thank you.
Good afternoon. Thank you, committee and members. My name is Ashley McReynolds. I'm a parent from here in Baton Rouge, and I'm a mom to an amazing little boy named Cooper, who some of you know, who is diagnosed with Prader-Willi syndrome, which happens to be a genetic disorder. And abortion was actually, it never even came up. I never had any markers drawn at all during my pregnancy when discussions with my OBGYN, and they asked, do you want to have these markers drawn? And I was like, well, what do they show? And he laid everything out, and he said, is it going to change your mind on, your decision? And I said no, so we never even had them drawn. I'm very much pro-life, as is my husband, but sitting here today, I question the phrase pro-life that's being used, and here's why. Pro-life doesn't stop after a child is born or delivered. Louisiana has over 13,000 children with developmental disabilities waiting on a waiting list for services. 8,000 of those 13,000 receive absolutely no other service at all for parents to help raise these children that cost enormous amounts of money. We struggled for years, and most of y'all know my story, for years providing just to keep our son alive while we waited for a waiver or for funding through Capital Area Human Services District to help out. All the votes in the House on this bill from pro-life legislators say they're pro-life, but they're not voting pro-life through a child's lifespan. So Senator Clater, you are correct, and you have voted pro-life through the lifespan of a child into adulthood. And most of you on this committee have voted that way in the Senate. But I don't see it from the House of Representatives. So for me, sitting here, the question is, pro-life isn't just about a mom carrying a child that might have a genetic abnormality, but my 10-year-old son, who does live and thrive with a genetic abnormality, needs services to stay alive. And your votes are pro-life. So thank you.
Thank you very much for your testimony and your time. The committee really appreciates it. Yes, sir.
Mr. Chairman and members of the committee.
Wait, just 1 second. I think they wanted to address Ms. McReynolds. Just for 1 second, if you could. I think you've touched a few hearts, and they want to tell you that.
Yes. Thank you, Mr. Chairman. And Ashley, I do know your story, and I really appreciate you coming to the table making that comment, because I am pro-life all the way through, because it's beyond just the birth of a child. And I say it all the time. I believe in life from the womb to the tomb, and all the things that go along with that. And so I just want to let you know how much I appreciate you making that comment. And as we talk about and debate issues, that we take the entire issue in its entirety as we debate issues, talk about what's important and what should have priority in our state. So I just want to let you know how much I appreciate that.
Thank you for that, and I appreciate your continued support as well.
Thank you so much, Senator. Senator Colon?
Thank you. And I just wanted to ditto that. We make tough decisions all the time, and you know, I'm happy that I've always fought so that your child can get a waiver, and I always will. And thank you for coming and say that it just touched my heart.
Thank you.
You did, and I think each and every one of us on this committee that see the plights of so many families, I think we all echo the same thoughts as the senators have. Thank you for your testimony.
Thank
you. Mr. Hunt?
Mr. Chairman and members of the committee, normally on issues relating to abortion, I'm talking about that interesting public policy area where constitutional rights run headlong into religious convictions. But this morning I hope to offer a different observation on this issue, maybe a different perspective. And it's this, bear with me if you will for a second. 15 years ago, no one knew what West Nile virus was. And I got a fast education in West Nile virus when it took the life of my father in 2002. And not many people had heard of it at the time, but we certainly know what it is now. Last year, globally, temperature records for the year shattered every historical record for temperature. If this year continues, as the first 5 months have continued, we will shatter last year's record. As a result of this, tropical diseases, or diseases that were once primarily confined to the tropics and equatorial areas of the globe, are on the march. And so we have, in the last several years, seen the arrival of chikungunya. I can't even pronounce it, much less spell it. And just in the last year or so, we've seen and learned something about the Zika virus, which first made itself present in Brazil, but is now marching north and south from there. I don't even know the origin of the Zika virus. And it already threatens Puerto Rico. I don't know if this bill would affect a woman who is pregnant and who has also been infected by the Zika virus, but I think probably all of the committee members have read enough about it to know what impact it is having on developing fetuses and embryos. And I suggest to you that it won't be long before someone, some legislator, some office holder is going to get a call from some woman who's in that box and who's going to ask why this option has been closed off to her if we go down this path. Now, we do hear a lot of talk around here about getting the government out of our lives, but I can't think of any instance quite comparable to that scenario where the government might involve itself in what has to be one of the most difficult decisions that a woman might make, and certainly one of the most private decisions, and a decision that I suggest to you, as has been stated before, that really should be between her, her God, her family, and her doctor. Thank you. That's all I have to say.
Thank you very much. Question by Senator Brown?
I must applaud you for saying some of the things you said, because just yesterday evening, colleagues, if you pull up your most recent issue of the government magazine, we get a magazine that tells us about legislation and current issues all throughout the nation. Just yesterday evening, I just read in my office that the Zika virus, you stopped at Puerto Rico. The Zika virus, according to some of the professionals who did this article in the government magazine, is prone to threaten the southern part of the United States more than anywhere else in this nation. And it also said that it would be much more catastrophic to some of our less socioeconomic and impoverished areas here in Louisiana, Mississippi, Alabama, Florida, and they were specific in naming the states. And to take it a little bit further, I think you would drawing the rationale that if this bill passes and a doctor diagnoses a patient or woman with their child having this virus, and that woman would want to make a decision to abort and possibly conceive again, that would not be an option. Am I correct?
I guess the proponents of the bill can answer that better than I can, Senator, but that's my take on the bill.
Right. So I want to applaud you for bringing that out, because as you said, and I was brainstorming more as you talk about the changes in weather. I had never really thought about that parallel, but a lot of the changes in weather that we are having is truly bringing some of these diseases that have never hit the United States, but they're bringing them here. We even are dealing with the changes of the weather. I come from that area that had a tornado, and I'm 44 years old. I've never seen a tornado hit Assumption Parish as bad as it hit 2 months ago. So those are realities that have byproducts, and shame on us if we put ourselves in a box with indirect legislation, only to learn in the future that we wish we had not done certain things or put certain things in law. Thank you, sir.
Thank you very much. The board is clear. Representative Edmonds, would you like to close briefly? Please. I'm trying to keep us going because we have a bunch of bills and we've got to be on the floor at 3.
Let me go back to the bill itself, because I think Senator Brown is...
One second, because we don't like to interrupt anybody in closing. I do have Senator Clayton. Did you want to? Just punched in at the right time. Okay, so you want to? Okay. I'm sorry. Please continue.
Senator Brown, I appreciate your concern on that, but when it comes to a virus or other virals, this law brings us back to proposed law provides the purpose of proposed law. Genetic abnormality means any defect, disease, or disorder that is inherited genetically. And so, and then we go on to list about 10 of those specifically that is reflective of this particular statute. So I think we're real clear, pardon me, in our legislation that we're not talking about other diseases or something that, and I can't suggest what another legislature might want to do or a legislator might want to do down, but this particular statute, I do not believe would allow those type of items. Mr. Chairman, if you made mention a few moments ago about any other language that we might want to clarify, and if you thought it would be of any help, I certainly, I don't mind either working on that and bringing it back to you, if that, whatever your decision would be, if that would if it pleases the committee, I'll be glad to do that, or I'll be glad to work on it between here and the floor. Either way, whatever you think would be the pleasure of this committee, I'd be glad to do.
Thank you so much. I do have, y'all want some questions, more questions?
I'd like to respond.
Okay, can we make a deal? About 2:05, we voting on this bill?
5 seconds.
Okay. Let's see, I have Senator Clayton. Senator Clater's up next. No question. Senator Luno, you were next in the queue.
I mean, if we can defer this for a week, I will be happy to sit down and work
Perfect.
with. I just, again, my problem is just it's unconstitutional like it is. Maybe we can fix it. I don't know.
I have no problems with that, Senator Luno. Obviously, we want to, even though some might consider this a controversial piece, obviously some might, or in this case, we want to pass good legislation. I'm not here to do anything but that. Do I believe this is good possibility for protection? We don't have a lot of case studies done. We don't, but conversation we should have, and I'd be more than happy. In fact, I'd be honored to do such. Thank you.
You want to do that? Senator Brown?
I just want to respond to your definition that you gave. You clearly read the definition, but you stopped at your last part. And the last part of your definition says, and any other type of physical, mental, or intellectual disability, abnormality, or disease. That opens the gamut to anything. Because anything can be determined to be an abnormality, or a disease, or a physical, or mental, or intellectual disability. That opens the door to anything.
I'm not going to spend a lot of time, but obviously we can look at that. But I don't think there's any way to combine inherited and then together. But again, that'd be another discussion another time.
I just want to point out and make it clear.
So your thought process,
Intentfully or unintentionally, you left that out.
so your thought process is do a little bit more work and come
Yeah,
back
that'd be
next
great.
week?
Yes, sir.
I defer now to Senator Barrow, she had the motion originally on the table.
Yes, and Mr. Chairman, I was kind of thinking that we would try to work on it between here and the floor, because we're getting late in the process of the session.
Well, just so you'll know, we do have to meet next week because the House does have some bills coming up. Now, we will clear our agenda up for what's in the queue, but the House has some more bills coming up next week. So just so for your informational purposes, we will be meeting next week as a committee.
Well, I guess, I trust you, Representative Edmonds,
Thank you,
that
sir.
you would work with the committee, that you would try to iron out all the concerns and work on language that could be agreeable, that we can all kind of agree with and kind of ensure that it won't end up in court, although we can be constitutionally challenged on anything at any given time. I just want to make sure that I say that on the record. But if it's going to be the will of the committee not to work with him between here and the floor, then I would withdraw my motion because I don't want the bill to die. But we do that all the time. And so I would hope that the committee would consider that.
Okay. Senator Clater, did you want to add to the discussion?
Yeah, I do. I want to thank Representative Edmonds for wanting to work on this. and
Sure,
getting the
thank you,
right
Senator
posture.
Slater.
So I'll work with you on it.
Thank you.
I think what I'm hearing, unless somebody disagrees, is the representative would love to work with the committee, and we'll bring it back next week. We'll put you first on the
Perfect.
agenda, and I think we'll be able to fast track it if everybody came to. Yes. So just from a committee standpoint, we thank you because I think
Yes, sir.
everybody wants to support you.
Okay.
So we'll get to work and we'll see what we can come up with between now and next week. Anybody's opposed to that? Well, I think we heard a lot, so next week we'll look for kind of some amendments and
Thank
maybe
you,
we'll move you
Thank
quick.
you, Mr. Chairman, and thank you, members, for your good discussion, and we'll work hard at it.
And I want to thank the committee members. This was a really good debate. Y'all did a great job. Representative Wilmot?